Government Law Review, Volume 17. Thank you all for coming to today's symposium, Federalism, Social Media, and Free Speech. We are delighted to present our speakers who are experts in this field and will each offer a unique perspective on the intersection of free speech, the digital world, and government powers. I'm happy to introduce Paige DeCecco, who is Government Law Review Volume 17's Managing Editor for Business and Production. She was in charge of this whole symposium. She came up with the topic for tonight last summer, and things have only gotten more interesting since then. So thank you, Paige, for all the hard work in bringing this to us. Thank you to our faculty advisors, Patrick Woods and Ray Brescia. And thank you to our speakers. And thank you to everyone else who helped us, business office and everyone, and Professor Clark. So I'll turn it over to Paige.
Hi, everyone, and welcome to Federalism, Social Media, and Free Speech. My name is Paige DeCecco. I'm the Managing Editor of Business and Production. So I listened to the Moody v. NetChoice oral argument, and Justice Thomas said something that didn't leave my mind. I thought about it. He said that he's been fortunate or unfortunate to have been here for most of the development of the internet. And that stuck with me because I think that we all feel similarly about that. We all know that the internet is a strong force, impacts a lot in our daily lives, but we can't really answer affirmatively, definitively, whether the internet is all good, all bad. I think there's a lot of bad things and a lot of really great things about the internet. And the symposium is going to explore ways in which we could manage the good and keep a balance of both the good and the bad that the internet provides us. I would like to thank Professor Clark for moderating the event today. From the beginning, he was very happy to help and moderate, and I enjoyed meeting with him in his office. He reminded me how far-reaching the internet and social media is. It impacts so many aspects of our lives, from issues such as domestic violence, connecting with family and friends. It goes international, education, children's self-esteem. It's in every one of our lives, every single second of the day. So a little bit about Professor Clark. So Professor Clark is a professor of law here at Albany Law School. Some of you may have had your first real introduction to the First Amendment in one of his classes. He joined the Albany Law School in 2000. Prior to joining Albany Law, he worked in private practice with Winston and Strawn in Chicago, where he specialized in employment-related appellate litigation, and he served as visiting professor at University of Toledo College of Law. Professor Clark began his legal career as a law clerk to the Chief Justice of the Supreme Court of Indiana. His research interests include employment discrimination, federalism, and lesbian and gay rights. He received his bachelor's degree from the University of Tennessee and his Juris Doctor from Yale Law School. And Sarah already thanked some of the people. I would just like to reiterate that thanks. I'm incredibly grateful to Sarah. I know you didn't want me to thank you, but thank you so much for all your help. Patrick Woods, Professor Brescia, and the people at the business office, communications, marketing. It was a pleasure working with all those people, and they did a great job helping me with this event. So without further ado, I'm going to hand this over to Professor Clark.
Thank you. Thank you very much, Paige, and welcome, everybody. I am going to stick tightly to the script here. We're asking our presenters to see if they can hold their remarks to 10 minutes each, so we'll have time for some questions at the end. The first speaker that we have, and I'm trying to struggle to read with my glasses in this little type here, is behind me. We have Professor Leslie Y. Garfield Tenzer from Pace University, where she is the university's Elisabeth Haub, at the Pace University Elisabeth Haub School of Law. Sorry, I've already butchered it. She is also the host and producer of Law to Fact, a podcast for students studying the law, and the host of Legal Tenzer. I like that. Her scholarship and teaching focus on regulating conduct in the digital age. So that seems perfect for us. Without further ado, thank you very much for joining us here, Professor Garfield Tenzer.
Thank you, Sarah, Paige, and the Albany Government Law Review, and thank you, Professor, for inviting me to speak today. So the focus of today's discussion is federalism, social media, and free speech, and I wanted to discuss an issue of federalism that concerns free speech, and that is the issue of whether states can regulate social media content in light of Federal Rule 47 U.S.C. 230. The issue is particularly ripe for discussion since the Supreme Court, as Paige pointed out, is currently contemplating whether two states, Florida and Texas, can dictate the kind of content platforms may sometimes ban, and that was where she gleaned the comments from Professor Thomas. I think it's worth providing you with a little historical context of Section 230 to help you understand what it is at issue and lay the foundation for the discussion that my esteemed panelists will present today. Congress adopted Section 230 as one provision in a much larger bill called the Communications Decency Act. The act aimed to prevent minors from gaining access to pornography on the internet. Now, keep in mind, this was 1996 when the internet was in its infancy. Interestingly, little footnote, the Supreme Court actually subsequently struck down all of the Communications Decency Act as overly broad, except Section 230, which somehow survived. So back to Section 230. Two congressmen, a Republican, Chris Cox, and a Democrat, Ron Wyden, don't see that much today, sponsored Section 230, and it provided that no provider or user of interactive computer services shall be treated as the publisher or speaker of any information provided by another information content provider. So in other words, Section 230 was a safe haven and is a safe haven for interactive computer services, which include social media sites. This means that these providers can't be responsible for content posted by third parties. It leaves interactive computer services or platforms free to post and not post content that is in keeping with their mission. Representatives Cox and Wyden recognized that if we held interactive computer services responsible for all the content published on their sites, then these ICSs might quickly go out of business. At a minimum, there would be no incentive to create new services. And so Section 230 came into being and provided this safe harbor. It basically freed platforms from the obligation and expense of having to defend themselves from countless lawsuits. Consequently, Section 230 was dubbed 26 words that created the internet. Now, interestingly, just to put this in context, again, as I said, this was 1996, and there were no social media sites at the time they adopted it. The first site was 6 Degrees, which was in 1998, which is a precursor to LinkedIn. But the definition of interactive service provider was broad enough, and social media sites seemed to morph quickly into Section 230 coverage. Because social media companies were not policed, and because content could appear on their websites without legal liability, most websites developed their own set of self-regulating standards under which an individual could temporarily or even permanently ban inflicting harm. In 2021, Twitter, now X, Facebook, now Meta, and YouTube had such regulations. Twitter, for example, had a civil integrity policy, which at the time prohibited glorified violence. And then came January 6th. On January 6, 2021, then President Trump posted a video to Facebook, Twitter, and YouTube showing demonstrators storming the Capitol. Several posts appeared favorable to those engaged in the raid. And on Twitter, Trump said, and I'll quote this, "These are things and events that happen when a sacred landslide election victory is so unceremoniously and viciously stripped away from great patriots who have been badly and unfairly treated for so long." There were other comments as well, and so Twitter felt that this violated civic standard policies, and on January 7th, Twitter permanently banned Trump. Facebook banned Trump for 2 years, YouTube for a briefer time. And just to keep you completely up to date before I go on, he's back on everything. So the Florida and Texas legislatures saw these bans as an effort to stifle conservative voices. And so each state quickly adopted its own legislation aimed at prohibiting the sites from limiting particular viewpoints. Florida adopted SB 7072, and this bill sanctioned platforms for knowingly deplatforming a candidate for office. It also prohibited shadow banning, which is the practice of limiting or refusing or removing, I should say, a user's exposure to posted material without the user's knowledge. And it gave any person in Florida a right to bring a cause of action for a platform violating the law. The Texas bill, which Governor Abbott signed into law, holds that platforms with more than 50 million users may not remove or restrict any user based on content. Individuals who are wronged by that are entitled to declaratory relief. That these laws were politically motivated is not in question. In signing his bill, Ron DeSantis said, the social media site's primary mission seems to be suppressing ideas that are inconvenient to their narrative or which they have purposely disagreed. The state senator who sponsored the bill in Texas noted that the platforms drive a narrative that silences conservative viewpoints, which is tantamount to discrimination. So NetChoice then sued, and as soon as the bill passed, NetChoice, a lobbying consortium with members including TikTok, AOL, Etsy, and X, and the Computer Communication Industry Association brought suit against Texas in the Fifth Circuit and Florida in the 11th Circuit. In their suits, they asked that the laws be stricken, but at a minimum, that states be enjoined from enforcing them until the lawsuits were resolved. And the two lawsuits took quite different paths. In Florida, the district court granted the injunction and the 11th Circuit upheld it. The circuit found that the statute impacted the platform's constitutionally protected editorial judgment and violated the platform's Fifth Amendment right because it compels them to disseminate speech with which they disagree. So, for example, if a candidate for office wanted to post a racist comment, that platform would be banned from blocking it, even if the platform disagreed with the comment. The district court in Texas also granted the preliminary injunction, but the Fifth Circuit, in a per curiam opinion, lifted the injunction. That decision went up to the Supreme Court, and a majority of the Supreme Court overruled the Fifth Circuit and sent it back down. Then the Fifth Circuit, with one of the judges being Judge Oldham, who prior to this had been the general counsel to Texas Governor Abbott, authored a 113-page opinion saying that the law was valid and criticizing pretty much the Florida opinion. These decisions then went back up to the Supreme Court, and those are the oral arguments that were heard on February 5th. The two states argued that the website's practice of content moderation was in effect censorship, and that censorship violated the First Amendment. Several justices on both sides of the political divide raised concerns about the First Amendment. For example, Justice Sotomayor suggested that the states violated the platform's constitutional rights by telling them what they could and couldn't post. Justice Kavanaugh quoted an earlier case and said that the concept government may restrict the speech of some elements of our society in order to enhance the relative voices of others is wholly foreign to the First Amendment. And Justice Roberts took issue with what he perceived as the state regulating the public square. The three conservative justices seemed to side with the state, suggesting that the content moderation was a euphemism for censorship, though. And those three are Alito, Gorsuch, and Thomas. So we're awaiting a decision, but I'll end with my prediction. Despite the court's fluency with contemporary media like Etsy, Gmail, and Tucker Carlson, all of which were raised during the oral arguments, I think the court is still, as Justice Kazin said in another case, not the 9 greatest experts on the internet. But even more to the point, I think most of the court will look to the precedent of Miami Herald versus Ternillo, a case that was cited regularly during the oral arguments. That case held that Florida, again, can't require a newspaper to provide space to political candidates. And I think the same is true here. State action regulating private company content is a clear violation of the First Amendment, and one with which, based on oral arguments, the court is likely to agree. Thank you.
Thank you very much. Next up, we have Professor Roy Gutterman, Director of the Tully Center for Free Speech, and he's Professor of Communications Magazine, News and Digital Journalism at the Newhouse School of Public Communications, Syracuse University. He writes and speaks on media law, free speech, and the intersection between courts, journalists, and legal education issues. Without further ado, Professor Gutterman.
Okay. Thanks for having me. I'm sorry I can't be there in person, but this is the next best thing using the internet, which is on tap for today. So I'm talking about a case called Murthy versus Missouri. For those of you who have followed this in the news, it started as Missouri and Louisiana versus Biden. So let me take you back to the Western District of Louisiana and quote directly from Judge Doty's 155-page to start things off. He framed this case as arguably the most massive attack on free speech in U.S. history. I don't know where we go from a statement that hyperbolic. It's almost a mic drop at this point. But let's talk about what this case is about and how it got to the Supreme Court. So during the height of the COVID-19 pandemic, officials from various federal agencies and departments, including the CDC, the FBI, the Department of Justice, and the Federal Trade Commission, approached certain social media entities to ask them, or if depending on how you feel about this, coerce them or force them to take down what could easily be described as mis or disinformation regarding COVID-19 policies, vaccine issues, mask mandates, the public shutdowns, all these hot button public issues that have adopted sort of this life of their own among conservative speakers. And I don't want this to turn into something that's political. And I'm certainly not an apologist for any administration, Democratic or Republican, but this is another one of these free speech cases that has taken on a real partisan bent because all the speakers who were deplatformed would identify as conservatives. So this is one of the more significant cases on deplatforming. And it came to the Western District of Louisiana on an injunction with the states of Missouri and Louisiana taking up the cause for some of their citizens who were deplatformed and wanted and filed for an injunction to prevent the administration from further deplatforming their citizens. There's a significant standing question for those of you who are fans of civil procedure litigation when those do pop up. So, as I mentioned, Judge Doherty was the district court judge who handled this in his sweeping 155-page decision, memorandum on the injunction, which at points has some beautiful elements and beautiful quotes from some of our favorite, our greatest hits of First Amendment cases and First Amendment speakers. I mean, he quotes Madison, and you don't see that happening in too many cases. But again, there's a degree of hyperbole with his rhetoric and his opinion. And again, 155 pages for a district court ruling on an injunction may seem a little excessive, but who am I to question a judge's right to write as long as he can, or to encourage his law clerks to write as long as they can. So the injunction was challenged at the Fifth Circuit and largely upheld, and that's what got appealed to the U.S. Supreme Court, and that's what was part of the argument on the 18th of March, which if you did listen to the argument or read the transcript, that the arguments were all over the place. And it was interesting to hear, and people are trying to figure out where the court's going to go based on the questions, and that's not easy to really get to. So the overall constitutional question here is whether the federal government violated the First Amendment rights of these speakers by encouraging or coercing the social media platforms, these independent, publicly operated private companies, whether they were kind of coerced into doing the government's censoring for them. That's colloquially called jawboning, which has gotten renewed interest in recent months and years. For those of you who are interested in both history and perhaps biblical studies, this comes out of the 1960s, particularly the Kennedy administration is credited with using private industry to shake down the steel industry and wages. And that's taken on a life. Again, the origins of the term for political scientists trace it back to the biblical story of Samson, who defeated an army with the jawbone of a mule or a donkey. It's a good sounding story, and that has become a political science term for the government trying to leverage private industry to do its censoring for them. And the Supreme Court it ruled on this in a 1963 case called Bantam Books versus Sullivan, where the state created one of the censorship commissions and a morals commission to police offensive literature, and sent a menacing letter to some book distributors with a list of books that that this agency found offensive, and encouraged the distributors to not distribute the books and therefore engage in censorship on behalf of the government. So this has had a storied history with at least one Supreme Court opinion ruling on the First Amendment issues on that. And this case also implicates, again, a case that Professor Tenzer just mentioned, the Tornillo case, which involved a state statute that required newspapers to print on demand from political candidates, people running for office. And that was deemed to be an invasion of the First Amendment rights of newspapers, requiring them to publish content regardless of whether they wanted to publish the content. And that state statute in 1974 was also ruled unconstitutional. But, fast forward to contemporary times, we've established that the internet is not like a newspaper. Some of the early internet cases raved about the infinite space we have in cyberspace for editorial viewpoints, opposing viewpoints, dissenting viewpoints, fringe viewpoints, and the law and the enforcement of law has largely held off on regulating that. But we're now with contemporary social media, which has achieved a level of prominence that perhaps the initial lawmakers who in the 90s couldn't envision or didn't want to envision. And perhaps the success of these internet companies is also based on the hands-off approach from Section 230 and the enforcement of that law, which then leaves us where we are today with the Supreme Court weighing a whole broad range of social media regulation cases emanating from all over the country. So the case now, Murphy versus Missouri, will further test what the line is between either coercion or or encouragement. And I'd just like to end with the one issue on the concept of government speech. The government does have a right to put forward public policy statements and speak on public policy and correct the record and issue statements of with legitimate value. As a former reporter, I had been approached over the years by government officials that wanted me to write something or didn't like the angle that I took on something, but I never felt like threatened or coerced. So perhaps I'm lucky, but there is a line between the threat to engage in some sort of regulation or prosecution and the approach to correct the record or make sure the people and the public readers and followers have access to legitimate, accurate information. So in some ways, we're trying to litigate what's accuracy and what the speaker's rights are in these settings, and even whose First Amendment rights will play take prominence in these discussions. So I yield the floor to my colleagues. Thank you.
Thank you, Professor Gutterman. Next up, we have Professor Chander. Anupam Chander is Professor of Law and Technology at Georgetown Law School. He's an expert on the global regulation of new technologies and the author of The Electronic Silk Road, a book that discusses the law as it relates to global internet commerce, and also has some relation from law school to Ray Brescia. I'll add that person up. Welcome.
Thank you very much, and thank you to Professor Brescia, Dean Brescia, for the kind invitation to join you all today. It's an honor to participate in the Albany Government Law Review's symposium on this incredibly prescient topic that they chose many months ago, when none of us expected to be as hot as it's turned out to be. What I want to do this evening is simply talk very quickly about the Montana TikTok ban. And so I want to share my screen here. Okay. Sorry, here we are. I assume that's working. Okay, I'll take that. That's that you can see my screen. So, as many of you will know, in sometime last year, TikTok became a very big issue in the state of Montana. And earlier on, from November through December and into the late winter, many states had banned TikTok, but only for government devices and sometimes for government networks. Okay. Montana went a step further. It banned it in the private sector as well. So a very substantial precedent for banning TikTok that we've seen play out in the courts. Of course, we saw in 2020, then President Donald Trump banning TikTok in August of 2020, just months shy of the election. And in that case, we saw that it was TikTok that would go on to ban Donald Trump or some of his videos from the app, rather than Donald Trump successfully banning TikTok in 2020 in the United States. And again, that was because of the courts. And again, as you can imagine, this is 2024. The Montana TikTok ban was supposed to be in effect as of January 1 of this year. As you can see, if you travel to Montana, you can download TikTok and watch as many TikToks as you want to your heart's content. Okay, so how did this happen, and what are the implications for a federal TikTok ban that we may end up seeing? Let me just move on to the. This is the kind of the opening salvo. An act banning TikTok in Montana, prohibiting a mobile app store from offering TikTok to Montana users. And as you'll see, it begins by reciting China as an adversary of the United States, and TikTok being a wholly owned subsidiary of ByteDance, which has Chinese roots, and a recital that China, of course, exercises control over ByteDance, this Chinese-based company, and then goes on to claim TikTok gathers significant information from its users, accessing data against their will to share with the people, the Republic of China, which becomes very contentious indeed, a claim that I don't think that they have demonstrated. and then goes on to recite a number of concerns related to content on TikTok. TikTok fails to remove, may even promote dangerous content that directs minors to engage in dangerous activities, including but not limited to throwing objects at moving vehicles. I didn't get to excerpt the whole thing onto that screen, but I'll just keep on reading. Taking excessive amounts of medication, lighting a mirror on fire, and then attempting to extinguishing it using only one's body parts. Inducing unconsciousness, cooking chicken in NyQuil, pouring hot wax, attempting to break an unsuspecting passerby head by tripping him, licking doorknobs, etc. So you can imagine the concerns about TikTok are at a fever pitch in the Montana legislature that is passing this. And what does the bill do? Well, the bill bans TikTok from operating within the territorial jurisdiction of Montana. So if you have TikTok and you drive through Montana and you're sitting in the passenger seat, it should stop functioning within that state. There's a $10,000 penalty on either TikTok or a mobile application user for each time that a user accesses TikTok. Mind you that TikTok tells us that there are 170 million American users. That 10,000 penalty adds up for each of those users, adds up very quickly, even if it's just the state of Montana that is at issue. So this bill would operationalize itself by assessing penalties against both TikTok and app stores that facilitate TikTok's presence in the state of Montana. So Google and Apple in particular having the most prominent app stores in the country. Okay. And of course, you saw lawsuits. Here is Ms. Samantha Ilario, who brings a lawsuit that then bears her name, Ilario v. Knudsen, and Knudsen is the Attorney General of the state of Montana. And the judge assigned to the case is Judge Donald Malloy, pictured here. And the case is brought by Ilario, but also by other users and TikTok itself. Like the 2020 case involving TikTok influencers, and mind you, in that 2020 case, the district court reviewing that case held that TikTok influencing was an important First Amendment activity. So just for all the influencers out there, you have got courts recognizing the work that you're doing. So Samantha Ilario was such an influencer, using the app to publicize her swimwear brand to the people of Montana and beyond. Okay, so this is the issue before the court. Let me return quickly to the Montana State House in March 2023 as it's considering the TikTok ban. And this is as recited by the New York Times. And I love this colloquy. Would you agree with me that TikTok is the music played by the Pied Piper to steal this generation's heart and mind? Asked Representative Neil Durham. And the Montana ACLU director, who is on the stand here in this hearing, I'm sure a little bit of what you're getting at, the policy director says. Mr. Durham, the representative, follows up, asked Mr. Medrano if he would agree that this generation was, through TikTok, choosing the Communist Party, Chinese Communist Party, as their new god. Okay. So this is the discussions leading up to the app ban. So how does then the district court, when seized of this issue, decide the case? Well, the first big question is standard of review. And this is a critical question for anyone, evaluating these issues on an issue spotter. First, you have to ask, what is the standard of review for such issues? The plaintiff said this is strict scrutiny because this should be subject to strict scrutiny because the law is a prior restraint. It is a content-based restriction and a viewpoint-based restriction. On a variety of grounds, strict scrutiny should be applied. The defendants, the Montana state government, said, hey, no, it should in fact be intermediate scrutiny because this is only an effort to regulate content-neutral conduct. The court reviews various issues, says it's likely not to be a prior restraint, but we'll assume strict scrutiny for the purposes of this evaluation. Why? Because they say we don't have to decide this issue because it fails under intermediate scrutiny, and it would a fortiori fail under strict scrutiny. So we don't have to decide which of the two standards we must apply. Now let me go quickly. In order to pass strict intermediate scrutiny, it must advance important governmental interests, not burden substantially more speech than necessary, and it must leave open ample alternative channels for communication. And I will try to stay within my 10 minutes here, just I'm a little bit over. And here is what the court says. Well, it applies strict intermediate scrutiny here, and it says on all three grounds, it fails. It burdens more speech than necessary. It completely bans TikTok. It doesn't limit the application in a targeted way with the purpose of attacking the perceived Chinese problem. It's not narrowly tailored. There are many ways in which a foreign adversary like China could gather data from Montanaans. It could buy that data from data brokers. It could conduct intelligence gathering. It could hack other systems. So there are lots of ways that they could gather data. And it doesn't leave open alternative channels of communication. So you can't simply move over to Snapchat or Reels as an alternative channel. TikTok, the users testified, provides them a way to communicate with their audience and community that they cannot get elsewhere on the internet. And so this is not, you don't have enough alternative channels of communication. So I think I'll stop there, and I can talk more about these issues in the Q&A.
Thank you very much. Before we proceed to our next speaker, I've been asked to announce for our CLE participants that the code word is censor, C-E-N-S-O-R, and that should be available to you on your screen. Censor as your CLE word. Next up, we have Professor Francesca Procaccini, who is Assistant Professor of Law at Vanderbilt. She writes about federal courts, constitutional law, especially First Amendment. And her most recent publication is Social Network as Work. It introduces a new labor paradigm for understanding and regulating social media. So welcome, Professor.
Thank you so much. It's a pleasure to be here. So I'm going to move from sort of some of the attempts, perhaps unsuccessful state attempts to regulate social media from the states to a new idea that who knows in this court environment whether this will be any more successful, but it's at least untried, and I think a more, in my opinion, it's a more tailored fit, honestly, to the harms that we tend to really think about and also really care about when we think about social media harms. So the predominant analogies that we've been talking about and that sort of exist in the ether, right, are social media companies are common carriers or public accommodations or publishers. They prefer that one. Or, even in the TikTok situation, maybe like even the arm of a foreign state. And I would like to suggest that I think that we should think about social media companies much more the way we think about traditional employers, and really move from the paradigm of social media as offering a service to customers, right, the user as customer, to offering or sort of to facilitating a form of labor where the users are actually forms of are types of workers for the platform. Why should we think about it this way? First, most importantly, it actually overcomes a ton of First Amendment challenges if we think about social media through a labor paradigm. Two, it offers a ready-made regulatory framework, right? We have a really robust labor and employment regulatory system that that regulates speech that regulates speech already, consistent with the First Amendment. And finally, it regulates speech in a way to address the very types of harms that we're actually increasingly caring about on social media, which include harms to user safety, user dignity, and more democracy-facing harms in society. So let me briefly sort of make the argument for why this unconventional, I hope not too controversial analogy is a way to go and is a way for states to think about regulating these platforms. So first, I know you all don't probably think that when you log on to whatever, Facebook, X, that you're going to work, but let me tell you why it is actually a form of labor. So boil down really simply is the structural conditions that make work, that make labor, are all present in the social media context. What are these conditions? Well, first is employer control. Platforms really exercise an inordinate amount of control over what you are doing on the platform. We can get into the nitty-gritty, but generally speaking, you know, everything you are seeing, doing, clicking on, right, is preordained by the platform itself. And so all that input, which you are giving the platform by being on the platform, is the thing that the platform is profiting off of. And that's the second major condition here. That the major structural condition is that the platform is actually profiting off of your activity. Profit for what? For compensation. Obviously, we don't always get paid in a physical paycheck, though that's increasingly changing. Users, especially influencers, are getting paychecks directly from platforms. But if you look at labor law, and if you look at sort of labor theory, compensation in the form of an actual physical paycheck is not a necessary precondition to understanding a labor relationship. And just think for a second of all the unionization battles going on, like with graduate students or student athletes, right? They're not getting a paycheck, but they are arguing and they're winning the argument that what they are doing is effectively a form of labor for the university. So you've got control, you've got profit, you've got compensation. An imbalanced bargaining power is pretty definitional of labor in our regime, which obviously, you know, platforms don't need any one user more than any one user needs the platform. Information asymmetries is another structural condition that I recognize as being rampant and sort of definitional to both a labor regime and the social media regimes. And then finally, the creation of a social community that we spend most of our time at. I think a lot of us are speaking to you from work right now. We are here most hours of the day. And you know, it really infiltrates so much of our social community, and social media is no different. Happy to get into, you know, any of the specifics there, but at a very high level of generality, the argument is that the structural conditions of the workplace really actually map on quite well to the structural conditions of user to platform. Okay, who cares? That's kind of fun. Well, there's some really good First Amendment implications for understanding that relationship. The First Amendment, I can put it simply, works differently at work. It just does. I can't say everything I want to say here at the office to my coworkers. And there's a lot that I can't say here that I can say to a stranger on the street. And the First Amendment is perfectly fine with the government, not just because, I mean, I technically work for a private university, but not just because my employer has told me I can't say certain things, but because the government has imposed regulations on me and my employer on what we can say. So there's state action there. This is by law. But of course, the court has upheld certain workplace speech restrictions based on the unique environment of the workplace. What is that unique environment? Well, one, it's a confined setting that still permits ample alternative channels for communication, right? So I said I can't say certain things to my coworkers, here in the office, but I can certainly go shout them on the street. And so I have another venue for my expression. The workplace is inherently more coercive. Right, we have to be here. We need a paycheck. We need it to live. And finally, our work speech is intricately bound up with commercial conduct, right? What we are doing here is, even as we're speaking, is really a form of economic activity, or is bound up with economic activity. And again, I would submit that the same constitutional conditions are present actually on social media. It is a confined setting. We actually do still have an outside world in which we can go shout what we want. It is actually a more coercive environment for a number of reasons. Again, for the sake of time, I won't go into all of them, but how much we rely on the platform and how difficult it is to leave a platform or switch platform creates similar structural barriers, the same way that we can't leave work or switch jobs very easily. And as I've said before, right, it's intricately bound up in commercial activity. What we are doing, we might think we're saying hi to, our friends or grandma or whoever, just looking at puppies, but actually what you're doing is contributing to a multi-billion-dollar regime. That is the point of your activity there. That's why these platforms exist. So, where does that get us? If that's all true, it means that work law, which is a combination of anti-discrimination law, labor law, employment law, and tort law, but regulations on speech in the workplace offer a ready-made analogy for thinking about how to regulate social media. What kind of regulations? Well, Title VII, right? Anti-discrimination regulations. The NLRA has a ton of regulations on the speech that both employees and employers can say to one another. Employers are regularly required to disclose certain health and safety notices to their employees. Employers are prohibited from proselytizing at work. And employers are required to, or are not allowed to, retaliate for certain speech by their employees, right? So certain political speech, religious speech, whistleblowing speech, advocacy speech, workplace advocacy speech. And some states in particular have actually gone further and passed laws that protect workers, what they call lifestyle speech, right? So if you engage in certain lifestyle expression, that you have certain job protections against retaliation for those lifestyle expressions. And I think this maps on really well to actually the kind of protections, as well as regulations that we want on social media. How would these map on? An anti-discrimination, anti-abuse, anti-false speech, sort of through like the common law defamation type of false speech regulations that exist in the workplace could absolutely exist consistent with the First Amendment on social media. You could think about, rather than a 230 regime for liability for platforms, you could think about a Title VII liability regime for platforms, in which platforms are vicariously liable for the discriminatory and abusive conduct of their users when they know about it and fail to take reasonable steps to stop that abuse and discrimination from user to user. Disclaimer and disclosure requirements. We're constantly asking for more information about how platforms are working, about the decisions they are making. due process protections, right? So lots of states impose due process protections on employers when they want to, let's say, fire, like deplatform an employee, right? Like they have to give them some sort of due process, and you could mandate that by law for social media companies. User empowered curation options. So again, some states impose an obligation on employers to actually give their employees more say over workplace policies. That would look like user empowered curation options in the context of social media. And finally, I would just note that, wage and hour law and child labor law, I think, is particularly apt as an analogy here, right? We have laws that say you can't do this type of labor if you're under a certain age, or if you do this type of labor, we're going to cap the hours, or we're going to require certain compensation. And maybe you don't want to go that far, but certainly these are all, again, analogous ways of thinking about how to regulate platforms. So that's the brief, that's the very quick summary of the idea here, is that we have this ready-made, long-standing, ready-made regulatory regime that regulates speech actually quite effectively in the workplace, that doesn't overly entangle government in speech regulation, but helps to create a much more civil and dignified and democracy enforcing environment in the workplace. And if we can start to re-envision the relationship between platform and user to one of labor, then we can borrow from this regime, from this legal regime, to both overcome First Amendment challenges, but also offer creative solutions to the harms that we really care about.
Thank you for that provocative talk. I can't wait until we're all asked to sign up to organize Twitter.
That's happening.
We can talk about that in the questions. Next up, we have Gilad Mills, who is an LLM recipient and an S.J.D candidate at Harvard Law School. He has also received a degree at Tel Aviv University from the Faculty of Law, LLB, as well as his BA degree from Tel Aviv University in economics. His dissertation is a private law fairness doctrine, rethinking fairness in private law for accommodating a healthier media ecosystem. Welcome and thank you.
Thank you very much. Let me share my screen. Can you all see it? Yeah? Okay, thank you. So first, thank you very much for the introduction and for inviting me to speak in this wonderful and truly fascinating panel, especially right after Professor Procaccini with her innovative, I think, suggestion, which definitely requires more discussion. So I want to start by looking at contemporary the contemporary discourse, maybe from bird's eye view, and I believe what I'm about to say also represents what we've seen here. There seems to be general agreement that we have failed to produce sufficient accountability for social media platforms and to mitigate the harms they generate. And to address these problems, scholars and policymakers often start from an analogy, just like we've seen, whether common carriers, employers, as we've seen. It can be even an analogy to courts or legislatures, and trying through that analogy to either justify using the police power of the state to regulate the platform, or to derive similar obligations that would be applicable to platforms. But then the discussion typically devolves to the question of whether we can or should at all impose similar obligations because of First Amendment constraints that Professor Procaccini talked about, I think, very correctly. And then the discourse is somewhat, I would say, trapped in a dichotomy. And to regulate or not to regulate becomes the ultimate question that we need to address. And honestly, I think there's no consensus even across political lines about this question, making regulation very hard to achieve, even if it could be very beneficial. But nonetheless, I think we can find a shared goal across various proposals, which is that we want to make sure that platforms actually keep their promises, the promises that they are making both to users and to the public more generally. And we want to protect users and public expectations vis-a-vis these platforms. So a contractual approach, I believe, can do both can both achieve these goals by holding platforms liable for failing to uphold contractual commitments. This way we can promote accountability without the need for direct regulation or reliance on self-regulation. And this way kind of offer a way out of the dichotomy, or maybe a third route, if you will. This approach has distinct advantages and disadvantages, of course, but it has its own characteristics. For example, it too can overcome constitutional barriers, given that the First Amendment permits courts to enforce contractual speech-related commitments. It can overcome political deadlock. It is premised on reactive courts, reactive adjudication, rather than proactive oversight of platforms' decision-making. All these, there are other advantages which we can talk about later. But the point is that we can use it to complement or substitute direct regulation where it is inappropriate, insufficient, or unattainable. I think this approach can invite a dynamic interaction between public and private law interventions to gradually improve overall governance in this ongoing process of discourse between courts, legislatures, regulators throughout time. Of course, there are clearly some potential limitations to an approach that's premised on plaintiffs bringing contractual claims to courts. One being Section 230, of course. In the interest of time, I'm going to just say that both historically and I think for good reason, Section 230 is focused on tort-based liability, which has very different characteristic to it compared to contractual liability. And I want to say that Section 230 was not enacted to allow platforms to mislead users about what they are doing or to make fraudulent misrepresentations about the products they are providing. There's also contractual immunity that I believe should be invalidated for various reasons, and we can talk about it more later. But if we assume that we can overcome these obstacles, the real question becomes what obligations does the contract entail for platforms, and whether such obligations can actually help us achieve the accountability we would like to achieve. And in order to do so, we first need to acknowledge, and here I'm following Professor Procaccini, that this contractual relationship is very unique. And when we analyze it, it's crucial to let go of old habits that are more suitable for analyzing traditional consumer contracts. This is not a traditional consumer contract. For example, a common misperception in this regard includes the belief that the terms of service are equal to the contract. But the truth is that platforms use many vehicles through which they convey expectations about the service, and that way also shape the substance of the contractual obligation. These can include community guidelines, privacy policies. They are being made through news releases, are posted by CEOs on the platform, and are also embedded in the code itself. And all of which are part and parcel of the contractual arrangement itself. Another thing that is important is to understand that this relationship contract consists of several elements that have a relationship within themselves. And without understanding the different elements as a unified whole, we are missing something about the nature of this relationship. So we need to start from understanding what is the service. That this is from the user's viewpoint, right? From the platform's viewpoint, it would be the other way around. But from the user's viewpoint, they are receiving a service. And I brought a quote from Gillespie saying that content moderation is a service. And even if it's entirely accurate or just close to it being accurate, I think if we're looking at access to moderated content as the service, we understand first that users provide the content and platforms provide the moderation. and that representations about these moderations are actually about the material attributes of this service, which has legal implications to it. Furthermore, we need to understand that the standard of liability here is premised on best efforts commitments and not on strict liability, which is, again, very different from traditional consumer contracts. And the consideration, also Professor Procaccini talked about that, it's based on data and attention, which has its own unique qualities, and it has a cyclical relationship with the service itself. Because more data and attention improve the content moderation in order that allows platforms to get more data and attention from the users, and so on and so forth. So what we are seeing here, that the contractual paradigm that we need to use in order to truly understand the relationship is different. We have an array of norm generating instruments that create an ongoing barter of non-fungible assets with that are highly individualized, data, attention, etc. This relationship is inherently dynamic. There are various mechanisms for adaptation, and it is premised on best efforts commitments, which again creates a very significant divergence from classic consumer contracts. And I believe that this divergence also warrants a similar divergence in the legal response to this relationship. But do we need to develop new legal tools to address this divergence, or does contract law already have available tools for us to harness? And I believe that it does. From a theoretical perspective, I believe that relational contract theory can offer us many tools in this respect, because it was developed to address a very similar divergence in the contractual paradigm. This theory was developed to address contracts between producers and distributors, writers and publishers, employers and employees, partnership. This is the type of ongoing relationship. It has a specific structure to it, an incomplete relationship, and from this structure emanate specific norms and expectations that are inherent to the relationship, that you cannot avoid them. It's based on cooperation, on trust and solidarity, etc. And if you notice, many of these, or at least trust me in the interest of time, many of these are actually apparent in the social media contractual relationship. And we have already some empirical evidence that support this finding. Now, from this theoretical framework, we can better understand what are the obligations or expectations of parties in this interaction, and start understanding how to design our doctrine to respond to this reality. And the first step would be to define the legal duty. And for that purpose, we can use existing contract law doctrine that pertains to best efforts commitments, and says that whenever you have a best effort commitment, it implies a duty of fairness and diligence in performing the contract. What does that mean? So diligence is a known term, and fairness means limited loyalty, one could say. That is a duty to execute equitable balancing of interests between the interests of the parties. And in our context, it means that platforms must balance their self-interest in profit against users' various interests, such as safety, free speech, reputation. And when the platforms are sufficiently large, also they have to take into account the public interest in having public safety, in having a working speech environment, etc. And to be clear, I am not making this up. This is what platforms actually explicitly say that they are doing, that they are engaging in this very specific type of interest balancing. I brought you an example from X or Twitter with Elon Musk tweeting that above profit, they prioritize the public's interest in free speech. They commit to securing a public square that works properly. And they also engage in diligent, they commit to diligently work to keep hate speech and abusive behavior off the platform, again, attending for users' interests. So from this general duty, specific obligations can be derived in a gradual process of common law and with relationship to public law interventions when necessary. The first thing to understand is that platforms have an affirmative duty to consider users and public interest. And from that, we can start deriving, for example, a restriction on arbitrary decision-making, a duty to diligently prevent harassment and discrimination, hate speech, and a duty to enforce or a possibility to enforce their commitments to safeguard human rights, which are often made by platforms. This can also impact the systemic design and demand some procedures that platforms adopt in order to perform their work diligently and fairly as they are obliged to do. And I'm just mentioning that there are also some doctrinal tools that can help us mitigate some court's institutional limitations and some of the constitutional concerns, mainly fear of over-encroachment on platforms' decision-making. So to conclude, I offer revisiting the contractual paradigm, harnessing resources from contract law and adapting them to the actual reality of social media contracting, and doing so as a complementary tool or substitutionary when necessary for direct regulation. Thanks.
Thank you very much to all of our speakers for really interesting presentations. I have some questions of my own. I don't know if I should go to those, or we have questions other people would like to ask.
Yeah.
All right, I will kick it off then. And this may be to our first couple of speakers, or really anybody can jump in. I don't know if you can hear me. Can you? There you go. Now the mic's on. Now you can hear me. This first question may go to our first few speakers, or maybe anybody could jump in on this. I want to see if we can take off of the agenda here the idea that the social media platforms themselves are bound by the First Amendment, which seems to be a big point of some misunderstanding out there. So thinking back in 1968, in a case called Logan Valley Plaza, the Supreme Court suggested that shopping malls, privately owned shopping malls, might be subjected to the First Amendment as the new public square, as commercial activity was shifting from city centers and public sidewalks and streets to enclosed privately owned shopping malls. But then a few years later, in a case called Lloyd Court versus Tanner in 1972, the court overrules itself, decides no, privately owned shopping centers are not covered by the First Amendment, and so people don't have the protection of free speech. Now, in those cases, it's typically people on the progressive side who liked the idea of having the First Amendment extended to protect people who were speaking in malls, shopping centers. One of the cases involved a labor protest, and another involved, I think, anti-war or environmental protest, some sort of other protest. Today, it seems to be the opposite with the political polarities of this issue. Does anybody want to address, are the social media platforms themselves bound by the First Amendment?
Well, I'll pitch in for just a second. First thing I want to say is to be very clear, the First Amendment is not, the platforms are not a government entity, so they are not themselves bound by the First Amendment, right? Only the government has can infringe on your First Amendment free speech. Private entities can, of course, there's some limitations if you accept some money or something like that. But I think to your point, what the states are trying to do is to designate these platforms as common carriers. So common carriers are entities that serve the general public and consequently are bound by limited governmental rule and regulation. So, but I just, I'll let anyone else pitch in, but I think one of the things that needs to be cleared up, to your point, is that the platforms do not have to guarantee you anything. They're free to do whatever they want, at least of now, until, if these laws pass.
So Logan Valley was wrong and Lloyd Court versus Tenzer was correct. Shopping malls can suppress speech whenever they want. You want to?
Sharing the love and letting someone else do it.
I'll jump in. I mean, are people even going to shopping malls for their designated purpose, much less expressing themselves on issues of public policy?
No, it was the consumers at the shopping.
I know, I understand that. I'm being facetious about the state of retail establishments nowadays. Sorry, Zoom doesn't always capture the sarcasm properly. But again, Justice Kennedy and the Packingham case several years ago declared social media to be the new public square. That was probably the main talking point out of that case, which incidentally involved sex offenders' access to the internet. So again, we're in some of these cases, we're dealing with sort of fringe, disfavored speech, which then goes back to your other point of so much of our free speech law today is based on that progressive viewpoint that felt censored going back to the initial wave of First Amendment cases. We're going all the way back to the Schenck and Abrams line of cases, because those were leftists who were being prosecuted for their speech. And the great wave of First Amendment jurisprudence that we love to talk about today really involves the free speech rights to political dissidents from the left, civil rights advocates, labor organizers, and now today we're talking about the free speech rights of conservatives. The whole world is totally upside down nowadays. And again, as I said earlier, I don't want to get political on this, but that's the world we're living in right now. So so that's the world we're living in right now. That the people that were perceived as the power structure for decades are now feeling that they don't have a voice at the table with this big behemoth of unregulated, unmitigated social media.
Yeah, let me follow briefly just to close this out. So even with the internet's origins in the Department of Defense, and even with the signals running through public and privately owned networks to get to your house, there's no sufficient government intertwining here that we should take seriously the claim that some make that the First Amendment should apply to the social media companies and their activities of censoring people, if you want to call it that, or banning certain people. Anybody?
I mean, I guess there's the normative answer and the doctrinal answer. The normative
Okay.
answer we can each have different views on. I think Professor Tenzer is exactly right on where the doctrine is. The doctrine is absolutely no. In light of how, like, the most recent state action case involving exactly what you're talking about, which is highly government involved public access channels. I mean, government written all over the access channels. Even that wasn't sufficient to show state action for the court. So as a doctrinal matter, I think I would have to fail you on an exam if you gave me the answer that the First Amendment applies to the social media companies. But you could whatever, like, we could go back to the early to the first part of the last century and reverse that. Sure. I do think there's one way in which this is consistent though with like I think there's a way in which you can see two trends happening that might be consistent, or a reaction to them consistent, which is while the court has certainly moved away from the First Amendment applying directly to the platforms, it has simultaneously imbued the platforms with more First Amendment rights, right? So both of these things are happening at the exact same time. The First Amendment does not operate directly on the platform, and the platform actually has more First Amendment rights. And we see this across the board: commercial speech doctrine, Citizens United, the platform cases now. I mean, this is happening in various different areas in the First Amendment, but obviously companies are getting increased strength in First Amendment rights. And one way to be consistent about this is to just say, actually the First Amendment should really pull back across the board, that, you know, public shop, no, actually the First Amendment does not apply to the shopping center, and that's fine. But also the shopping center doesn't have as many First Amendment rights as the court has granted to it now. So there's a way in which, and you know, this is what I just think, but there's a way in which to think that the First Amendment actually should pull back across the board. It both applies in less spaces, but it also provides protection to a less strong degree as well. And what you do there is you get legislatures back involved. You get legislatures back involved in the process of determining how to protect speech, rather than just leaving the question to courts as to how to protect speech. Ultimately, this is a separation of powers question.
Do we undo
So
entirely?
can I pick up on
corporations
that
or people? Go ahead.
So I want to pick up on that. Of course, in the Texas and Florida cases, we see the legislatures directly involved, right? And the legislatures are saying, "Hey, you guys, you big platforms, you can't throw anyone off. If you have one kind of speech, you must have the opposing viewpoint represented. So you can't discriminate based on the content of the speech, and so you are." As Professor Tenzer pointed out, you're a common carrier of a kind. And they cite, of course, a shopping mall case in this context, Pruneyard, to argue that they have that there are these First Amendment obligations on the part of the platforms. That found a very skeptical court. If you listen to those arguments, and I don't know if. Maybe you might have two justices that could possibly, or maybe three justices that could possibly go in that direction. But I think that most of the court was really resoundingly averse to that idea. And so I think that we are going to see that. I mean, and I think, Pruneyard is a very narrow case. In peculiar case, there's a kind of interaction with the California Constitution in that case. And so, I think your basic proposition is correct, but it is one that's being tested, and people are trying to revisit that question even as we speak.
I don't want to talk over anybody. If there's anybody else who wants to speak on that.
If I can add just a couple of notes. I think, other than the doctrinal question, there's the substantive question. It's clear that applying the First Amendment as it applies to states is practically irrelevant. There's so much content, what Daphne Keller calls lawful but awful, that platforms have to take down. And if you apply the First Amendment, the social media would be just bombarded with content that would make the platforms simply ineffective. And another aspect I think that's important to note, maybe taking it back to kind of my areas, is that during the hearing, I think it was the Florida lawyer who said quite explicitly that, if they called themselves Democrats.com, we wouldn't have interfered, right? It's about what the platforms are actually saying that they are doing. And a lot of the legislation that we're seeing is actually based on kind of trying to enforce their commitments, trying to say, well, you have to consistently apply your policies, for example. That's a new part of the legislation. So I think we are kind of used to thinking about these issues from a First Amendment perspective, but there's also a very important voluntarily assumed obligations that we need to pay attention to. And I think to an extent, the First Amendment has to provide private people the opportunity to agree on speech norms that they want to interact with. So just a couple of notes.
On that, as I listened to your presentation, and maybe it was because we had just been talking about employment law as another possible paradigm, I was envisioning that surge of rewritten employee handbooks in the 1990s, and suddenly they had disclaimers that they weren't contracts and that nobody was bound to anything, that all of these nice procedural and substantive guarantees that people had weren't enforceable in court. Why wouldn't the social media platforms just react that way?
I think I tried to answer that question using the relational contract framework, and trying to show that this relationship, a contract is not enough, that like the terms of use are not enough to describe it. Okay, this is an ongoing relationship. Even if they would argue that this is not a contract, that doesn't mean that the court should accept it. So I think that way there are some obligations that they simply can't avoid. And if they want to make other representations, they will have to pay the reputational cost of other representations. And again, this is just one solution. I think the structure of the market won't allow them to do things that completely disavow all these obligations that they're assuming to the public.
And do we have a question from the audience? Yes.
My name is Daniela Yunao, 3L at Albany Law School. My question is about Chevron difference and potential implication to everything that we discussed today. Supreme Court is currently revisiting the Chevron difference decision, and we talk a lot about regulatory power of agencies to social media companies. And I wonder if you guys can, if all the panelists can address any potential implication as to the ruling of potentially overturning Chevron difference. Thank you.
I mean, I can start by saying, I mean, until I think I'm right in saying this, happy to be corrected by the panel, but till Congress gets its act together and actually does something at the congressional level and delegates responsibility for platform regulation to a federal agency. I don't teach admin law, but I don't recall Chevron really implicating the standard of review for regulations, for state regulations. Though it's an interesting, if I'm right about that, it's quite an interesting question to see the two bound up. I think we're still at the front line First Amendment question. We also don't really have, Commerce Clause questions lurking in the background. Though obviously, again, the TikTok ban, the potential ban on TikTok is raising some of the federal powers questions. So I think Chevron, Commerce Clause, these types of really interesting, what I'm going to call Con Law 1 questions are lurking at the federal level, but I think mercifully have less application at the state regulatory level. And that is also why we're seeing these types of cases bump directly, immediately up against the First Amendment, because that is the more salient provision. But like I said, it has been a long time since I've taken admin, so I could be wrong about that.
Yes.
Yeah, so we have two questions from the Q&A. The first is, would the First Amendment analysis apply more to social media companies if the government actually participates in the operation of the platform and attempts to influence whose speech is censored, as was a possibility revealed in the release of the Twitter files? More specifically, would it be in the best interest of the social media platform to draw a line of demarcation in their partnership with government entities to avoid being subject to the First Amendment?
Well, I don't, these social media companies are businesses first and foremost. So let's keep that in perspective. They don't really want government intervention. One of the things that I thought was interesting was that Justice Sotomayor talked a lot about Etsy. Clearly, these bans, at least when we're talking about the net choice cases, were aimed at the Twitters and Facebooks of the world, but it would implicate Etsy. And like, do you want to tell Etsy what they can and cannot sell on their website? I mean, that's kind of tangential in a broader reading, but the point of the matter is that they don't want any government intervention and they want to make money. That's really their goal, is to make money.
Any other questions for the audience?
Hi, I'm Ethan. I'm a 2L at Albany Law. My question, I'm not sure if I'm misunderstanding this topic, but what would be the source of authority for states to regulate these social media platforms that are, not based in the state in which is banning them? So for example, if a state were to ban, like say Montana were to ban Twitter, which is a California corporation, what is the argument for that authority, or is it strictly a First Amendment analysis there?
So if I'll pick up that question. Montana is using its own police power to protect its people. That is the asserted rationale of that ban. So it's saying just as it could say, hey, we in Montana don't want asbestos wherever it comes from, whether it comes from California or from Canada or Mexico or China, we don't want it. They're saying we don't want this other poison of TikTok. And so that's the basis. They're not saying, hey, you can't have it in South Dakota, you can't have it in California. We're saying you can't allow it to reach Montanans. That's the theory anyway. I do think that there are Commerce Clause questions in all of this that are very serious, and that requires a lot more than 10 minutes to try to give an overview of. But I think that's the argument from Montana's side.
We have time for one more question.
Hi, my name is Elisabeth. Hi, I'm Lisa Michelle. I'm a recent alum. My question is, hypothetically, if the Supreme Court does say that yes, states can use their police power to regulate how social media operates in their states, given that there are already differences with how the EU and different countries there treat things like hate speech and certain political speech that is banned. Does social media even continue to exist? It's a little bit philosophical, but how does that even work? Is it workable? Is it practical? Does it continue to exist?
I might just quickly point out that this is already occurring. That is, there are a host of state statutes that regulate privacy that are different across the country. California introduced this, California Consumer Privacy Protection Act. So a few years ago, and a number of other states have followed suit. So we already see that the companies are managing. Most likely they're ignoring much of the privacy requirements in many of the other jurisdictions. They just, like the GDPR, try to say, we're going to try to comply with much of it, the bulk of it, and hope that we fly under the radar elsewhere, because enforcement is lacking in most jurisdictions, even if you have a privacy law or a special law. A lot of these laws are being challenged, so age verification laws, for example, are being challenged across the country. And so we're going to see all these things, and Commerce Clause questions being raised, because how do you, in fact, ban an app? How do you tell an app store to geolocate everyone? You now need to know where everyone is all the time. Before you allow someone to download the app, you need to be able to pinpoint exactly where they are. IP addresses, yeah, they give you a vague sense, but IP addresses can be wrong. Okay, this thing doesn't say, oh, you can get it wrong. Okay, you tried a reasonable effort. It says if you allowed it. So now we need to know every time you're downloading something or updating an app, we need to know exactly where you are. So there's a kind of location verification that's built in, which has implications for all these apps and the use of these apps across the country, because people may not want to share their location, like their pinpoint location, to make sure that you're within Montana or outside Montana. IP addresses don't go by state boundaries. That's not the way IP addresses are allocated. They go to ISPs, which often operate across multiple jurisdictions. So you've got tremendous, questions in the way these things operate.
I just want to add, and I think Professor Mills was right that Section 230 was primarily for tort, but keep in mind, if you read the legislative intent, that the purpose of Section 230 was to avoid overregulation for fear that social media companies would not have the incentive to exist, and also for fear that no new social media companies could be created because it would be so onerous and so financially burdensome.
I just can't resist adding like one historical point, which is like companies give this argument every time regulation is on the table. So right in my most recent work, trying to figure out a labor lens on this, I go through all of the very non-controversial labor provisions that, or some of them are less controversial than others, labor provisions that I talked about today. You would have thought the sky was falling and that it would be impossible to literally have a workforce that was effective if Title VII passed, God forbid. And it's like, what, actually, like Title VII made things better at work. It didn't cause an economic collapse. And so I think that we should resist. I love the question, and I just think we should really resist the temptation to say that things will fall entirely if good, reasonable regulation is on the table. And I think social media is no different. There is too much money for them not to survive in the face of normal regulation that empowers and protects users.
Okay, unfortunately, that's all the time we have left tonight. I want to thank Gilad Mills, Professor Tenzer, Roy Gutterman, Professor Chander, and am I missing someone? Oh, Professor Procaccini, right there. I really appreciate the time and the effort that all of you put into this event. It was really a pleasure working with all of you, and I learned so many fascinating things. You could really just go down a rabbit hole with the First Amendment. So thank you so much for coming and joining us tonight. I would also like to invite all of you to a reception in the East Foyer, catered by Novo Kitchen. We will miss all you speakers there at the reception. We wish you could attend, but again, thank you, and I hope you have a great night.
Thanks a lot. It was very fun, very enjoyable.
Thank you
Thanks
for
a lot.
having us.
Thank
Quite well
you.
taken, Professor
Great
Procaccini. Thank you.
Thank you very much, and well done for organizing this.
Yes.
Bye, good night.
Good night.
Bye-bye.